So, should I say that?
Yeah. Good afternoon, Daniel Bornstein. As people are filtering into this webinar, I want to, welcome you. Want to, hopefully, to my friends, colleagues, clients, let you know that we are doing well at Bornstein Law, and I am staying healthy, and I hope you and your family and friends are doing so as well. Today we have a very ambitious program, but it's a very crucial program because at the core of what I do is often handle criminal behavior, violence, domestic disturbances in rental units. But instead of being a criminal attorney, I handle these disputes as it involves residential property, sometimes commercial property. What we're going to focus on is how do we handle a situation where we have nuisance behavior inside a unit and the decisions and choices we must make in order to ensure that we maintain safety inside our rental units. Again, I'm Daniel Bornstein. It's my pleasure to start. Buckle yourself in and let's jump in. The agenda for today's event. Hold on one. Will be as follows. The imperative of all of us to act when there's a threat to public safety and health. The eviction process, considerations when determining the foreseeability and seriousness of a threat, proper preparation of a 3-day notice, defenses that can be raised using temporary restraining orders, special protections afforded to victims of domestic violence, an overview of VAWA, the Violence Against Women's Act, and a word about new initiatives in our community policing and what these have as an impact on landlord-tenant law. Now, I want you to understand that I represent people in civil disputes. You as a property owner, or you as a service provider, property manager for property owners, have to recognize that you cannot sit with your head in the sand when there is a violent conduct occurring inside the unit. Why? Because you owe a civil liability, or you owe an obligation to tenants within the building to ensure their safety. And if it's foreseeable that criminal conduct or violent conduct may occur in the building, you've got to act or you create liability for yourself. And the difference in criminal law is the standard is proof beyond a reasonable doubt. In an unlawful detainer or eviction action, it's by a preponderance of the evidence. So we may have a situation where criminal conduct occurred in your property, but the police and the prosecutors are not going to indict a person for a crime. The crime may have occurred, but they're not going to prosecute the wrongdoer. I want you to understand that you do not have to wait for a criminal conviction to proceed if you have credible evidence that some sort of crime occurred in the unit. Violence, drug dealing, arson, any sort of theft crime as well. If you've seen it on surveillance, if you've got witnesses to it, you do not need to wait for a police report to act. And a lot of times my clients are like, well, the police aren't prosecuting, what should I do? And I ask you, do we have witnesses to confirm the misconduct? And if the answer is yes, then I say, well, you need to proceed, especially if you're dealing with physical safety of other people inside your building. And many people will say, Mr. Bornstein, but that's going to cost a fortune. And I say, I don't know how much it's going to cost. I know you have a legal obligation to ensure the safety and well-being of people inside your building. And if that means that you have to pursue an eviction action, that's your responsibility as a landowner. You don't necessarily have to wait for the crime to be prosecuted before you have the right to proceed. Let's briefly go over the eviction process at this juncture. So the eviction process is spelled out here. And for any of you, of course, it's my pleasure to send you this documentation as a PowerPoint slide presentation. I also have these charts in individual PDFs. You're welcome to distribute it. But generally, when we're dealing with nuisance or criminal conduct, let's say you have a tenant who has threatened another tenant with a knife. We don't serve a 30-day notice of termination of tenancy. We look at this chart and we serve a 3-day notice, and the type of notice would be to quit, because that's such a serious situation, you don't get a chance to cure. And we'll talk about that shortly. If the tenant, after receiving a 3-day notice to quit, does not vacate the premises, then you can file an unlawful detainer complaint. That's an eviction complaint. It's the tenant is unlawfully detaining possession of the premises because you served a notice, they didn't move out, and so you've perfected your right to evict. Once the lawsuit's filed, then you have to serve the lawsuit, and you got to get through this chronology to finally get to the sheriff's eviction or some sort of settlement with the defendant moving out. Generally, pre-COVID, 60 to 90 days to work yourself through the eviction process if we're dealing with the start of it with a 3-day notice. Sometimes it's longer. Very often it could be 90 days, maybe 75 days, but you're really looking at 8 to 12 weeks, if not longer. And I got to tell you, as time evolves with new laws coming in, with longer delay for service periods, things are taking longer with the court. So if someone calls me up and says, Mr. Bornstein, I just had someone engage in narcotics sales inside the unit. I saw them selling meth from a window in the unit. How long is it going to take to evict? I typically say it's going to be, if the person doesn't move out after we serve the 3-day notice, it's going to be about 90 days to work itself through the court. The big question you're going to have to ask yourself as a property owner, which often occurs, is whether the misconduct is so severe that it's a notice to quit, where you do not give the person the right to cure, or whether it's a notice to cure or quit. And it's a judgment call. And after having done this for 25 years, if not more, I'm always able to discuss it with you. A late night party, one-off, probably for sure a cure or quit notice. Someone threatens to kill someone or grab someone, it's a quit notice. So it's a matter of severity. And if you're simply looking to quiet down behavior, then it would be a notice to cure or quit. If it's, I need you out of the premises because your behavior is so egregious that you don't have the right to cure your behavior, then it would be a notice to quit. Let's look at these nuances with a little bit more specificity. So a 3-day notice to cure or quit could be to cure a nuisance violation or to cure a violation of a lease covenant. You bring in unauthorized pets. As I mentioned before, there's noise disturbances where you have people partying at night and it's interfering with the quiet enjoyment of other people. If it's intermittent, I would basically serve a cure or quit notice, which means you need to cure your behavior. And if you don't, we can file the eviction action, but it gives the individual the right to behave and to correct the problem. If someone's creating unsanitary conditions, you can serve a cure or quit notice. If someone is engaged in minor damage to the premises, cure or quit notice. Pay for the damage. You broke a window by accident, pay for the damage, and you can remain. Other lease violations typically cure or quit. Nuisance behavior like playing music too loud at night or too early in the morning, slamming doors, pounding doors. That's usually a cure or quit notice. And that gives them the option to cure the behavior. They could vacate, but that's unlikely. And if they continue with that behavior after having served a proper notice to cure or quit, then you perfected your right to file the unlawful detainer action. But there is embedded in that notice the right to correct the behavior. A 3-day notice to quit is much more aggressive. You're telling someone you've got 3 days to clear out of the unit because your behavior is so dangerous. What are examples? Arson, drug dealing, violence, domestic disputes with an imminent threat, and I want you to put an asterisk on that. We'll talk about that. Vandalism. I recently had a court trial with someone who took a bat to a glass door in a fit of rage. 3-day notice to quit. Prostitution, gang-related activity, serious threats, or other criminal acts. If someone is stealing packages from your mailroom and you've got it on surveillance, they don't get a chance to cure the conduct. When you steal from someone, you give up the right to be part of that community. You serve a 3-day notice to quit. It's egregious conduct that endangers the health and safety of others. The tenant must vacate the premises within the notice period with no opportunity to cure the underlying behavior. I want you to know that there are many law firms in the Bay Area that handle landlord-tenant matters. For some reason, my office has developed a real core ability to handle these nuisance-related behaviors, and I am comfortable with you calling me or emailing me and letting me know that you've got a strange situation with the tenant-tenant problem. There was threats of violence. Daniel, what should we do? And then we will have a discussion and make a decision as to whether the behavior is sufficiently egregious that we would serve a 3-day notice to quit, or whether we're going to give the person a chance to cure. Remember, if you choose a 3-day notice to quit, you're really on the path of filing an eviction action if the person doesn't leave. And that is, of course, expensive, attorney fees, it's cumbersome. And remember, you can't collect rent after you served a 3-day notice to quit. So you're also losing the rent money on that place. So we really want to be smart about when we make these decisions, but sometimes the decision is foisted upon you. If you have a situation where someone has a gun and they shot the gun and a bullet was discharged from that gun inside your building, 3-day notice to quit. And all of these examples are situations that I have dealt with over the course of my professional career. And I just want you to know that I'm very comfortable in this area. And generally, you got a messy unit, you're going to do a cure or quit notice. You've got someone setting the building on fire or lighting matches and trying to set something on fire, we're going to 3-day notice to quit. It's too dangerous. If you're aware of someone engaging in that type of behavior and you do nothing, and then that person does it again, and someone passes away out of a death, you've got extreme financial liability as a result of you sitting on your hands and not doing anything. How do we make these decisions? We need to ascertain how real and foreseeable a threat is. And again, I'm happy to dialogue with you. We will often serve a 3-day notice to cure if we're just dealing with an argument between two individuals. We have hotheads in a unit. They get upset. Someone pounds on a door saying, hey, turn down your music. The person responds, F you. What we have is a tenant-tenant dispute about noise. I usually serve a cure or quit notice. If in that discussion someone threatens physical harm to another, then we've got ourselves a more serious situation, and then we have a decision as to whether we're going to serve a 3-day notice to quit or not. I take threats very seriously. If someone touches someone in a violent manner, they're gone. If someone discharges a weapon or shows someone a weapon in the context of a fight, they're gone. Now remember, the best predictor of misconduct of an individual is whether they've engaged in that misconduct in the past. So where we have someone who is a nuisance, they tend to create future misconduct as well. And oftentimes I can serve a 3-day notice to cure or quit on misconduct that's occurred in the past. It occurs again. We may say, look, last time we gave you a 3-day notice to cure or quit. This time we're going to serve you a 3-day notice to quit because you cannot control yourself. It really is a question of severity and whether we have menacing behavior and whether we have the ability to serve that notice and sever the tenancy. And remember, you may have a tenant who's lived there 12 years. They have an off night and they threaten to harm someone and grab them by the short shirt collar. They lose their tenancy. I don't care if they've been there 12 years. I don't care if they've been there 20 years. You are not to put your hands on another person in a manner of violence when you're in a rental unit. Our society is too violent, and we have to police the property in a manner that makes sure others are safe. And remember, as I've repeated, if you don't do that, you face potential future liability if that violence occurs and you had already been forewarned about it because you were informed of this person's likelihood of violent behavior as a result of his past violent behavior. Here's an example of a 3-day notice to quit. And I want you to remember, in landlord-tenant disputes, the biggest question is whether you have properly prepared and properly served the notice. This notice is a properly prepared notice. It's a template, not a template, but it has names that we've just inhabited. But you just see we have the name of the tenant, the address of the unit, and in the body of the unit, we recite what fact pattern the person engaged in. We inform them that they've engaged in a nuisance conduct. We cite the civil code 1161-4 that they're engaged in a nuisance conduct. And because this is a San Francisco notice, we cite the San Francisco code. And we also provide notification that advice is available at the San Francisco Rent Board. I want you to understand this. While many of you may be comfortable serving 3-day notices to pay rent or quit, a nuisance notice needs to be drafted typically by an attorney to make sure it's done correctly. If someone has engaged in arson at your property, but your nuisance notice is improperly drafted, you can go to court and lose the case, not because you aren't able to prove the person engaged in nuisance, but because your notice was in error, was drafted incorrectly. And remember, there are brilliant tenant attorneys looking for mistakes in your notices in order to win the case. And they don't care that that person may be harmful inside that unit. Their job is to zealously represent them. And in the context of a landlord-tenant dispute, zealous representation is often keeping them inside that unit. So I want to emphasize, you want to make sure you draft up the notice correctly. You want to have an attorney who's comfortable with it. And we draft up the notice, we review it with the client, we make sure we can prove the allegations. And why is it important that we can prove the allegations? Because if you can't prove the allegations, you lose the case. Remember, you are the plaintiff. You are pursuing the lawsuit. You have to prove your case beyond a preponderance of the evidence, 5149, and you have the obligation. The other person can just minimize it. In the 3-day notice that I gave as an example on the prior PowerPoint slide, the fact pattern was you've engaged in a campaign of terror, you hammer on the walls, you appeared intoxicated, you threatened to beat up other tenants, and on one occasion you started to swing your fist at another, screamed F you and other obscenities, you intentionally kicked another tenant, your behavior is erratic, violent, and traumatizing. And the person has already sought a restraining order against you. That's a fact pattern. And guess what? This is a template of something that in fact happened. All day long, I'm dealing with dysfunction that's occurring in buildings. During the COVID pandemic, even though there's been moratoriums on evictions, there's always been the ability to proceed on a health and safety issue. And with lots of people inside the building not going to work, lots of dysfunction inside buildings. And my practice on landlord-tenant law became even more focused on nuisance-related behavior, because when people are cooped up in a building and they don't have free movement, all sorts of dysfunction arises. Drafting up these notices, you have to know how to draft them up, because this statement that's included in the notice is what you have to prove to a jury that raises to a level of nuisance that they should be required to vacate the premises. Defenses. So we served a 3-day notice. We filed the eviction action or the unlawful detainer action, and we're alleging a non-curable breach, a nuisance. The first thing that a defendant can allege is that the nuisance did not occur, or it's not as serious as you allege. And that's why we really want to be careful when we serve a 3-day notice to quit. We want to make sure, excuse me, we want to make sure that the allegations are serious enough that if proven, a jury will say, of course, this person has to leave the community. If you're dealing with night noise or someone pounding on a ceiling and you serve a 3-day notice to quit, you may get to trial and the tenant attorney will say, hey, yeah, he did something wrong, but he shouldn't lose his tenancy. You should have served a 3-day notice to cure or quit. This is not an incurable breach. This doesn't rise to the level of nuisance that would cause this person to lose their tenancy. So we want to be very careful about it. Before we file the eviction lawsuit, we want to make sure we have credible eyewitnesses. We want police reports if possible. Video surveillance, ideal. Photographic documentation as well. And remember, we have the burden to prove. We have to prove it beyond a preponderance of the evidence. Now, in my experience as an attorney, the biggest issue that I often face is I have an owner call me up and say, look, this person is harassing other tenants in the building, and all the other tenants want the person out, but they're scared to testify. They're scared of retaliation. They're scared of retribution. They don't want to say anything because they're concerned that that wrongdoer will hurt them when the wrongdoer finds out that they were the source of the complaints. What do? I don't need the name of the tenants who are complaining. I need to know what happened, that we have an eyewitness that's credible. I need to know the facts arising out of that disturbance, and then I can prepare a 3-day notice. If I go through with the case, I'm gonna need to potentially have that witness appear at trial. I may have to reveal the name of the witness during discovery, but remember, 95 out of 100 cases settle. They usually settle with a nuisance where the tenant moves out of the premises. So oftentimes, as long as I have that information, it's credible, I don't necessarily need to reveal the people who were engaged in the complaints until and unless it goes to trial. And what I often do is I will subpoena that witness so that at trial, when they testify, I will say, you did not come here voluntarily, you were subpoenaed to show up at court. That gives that complainer coverage so it doesn't look like they were initiating the dispute, but in fact, they were required to be there because they were served a legal document to attend to court. Generally speaking, though, I got to tell you, if I'm a tenant and I'm being harassed inside a unit, I have to have the courage to communicate it and be ready and willing to identify that wrongdoer in order for me to accomplish the goal of having that person out of the community. If I don't have any witnesses, it can be a problem for the case. Let me say that again. If I don't have any witnesses, it can be a problem for the case. I can have anonymous information that you have independently verified as accurate so that I can prepare a notice and I can proceed. I do this often with narcotics. People are coming to a building at all hours of the night and they're staying for 10 minutes. They're coming in, they're doing their transaction, they're leaving. Someone is selling typically drugs inside the unit. If they're selling drugs inside the unit, oftentimes other tenants and other units in the building are scared. They tell the owner there's all sorts of activity. The owner calls the police drag their heels. We don't get any sort of action by the police, but we know there's drug dealing going on. If I'm comfortable and confident that there's drug dealing going on because someone's seeing it, I can prepare a 3-day notice to quit for narcotics dealing. Remember, the standard in a civil case is beyond a preponderance of the evidence, 5149. It's not beyond a reasonable doubt. That's criminal law. So I will act upon drug dealing with anonymous information as long as it's credible. Because in the end, what do I know? A tenant who is dealing drugs in a unit, when you finally serve them a 3-day notice to quit, telling them exactly what they're doing, they don't want to stick around. They want to leave and move their business somewhere else. So as long as we're confident that we have good information that there's drug dealing going on, I will act upon it. And I don't have to reveal that source initially. If it goes to trial, which is typically unlikely, we will have to reveal that source. But generally, I don't at the inception of the matter. Hopefully that helps spell things out, because oftentimes I get owners who are saying the harmed tenant doesn't want to come be a witness. They're scared of retaliation. And I have to tell them, I'm not going to reveal that tenant's name in the notice. We won't have to reveal it unless it gets further into the case. And most importantly, as community members, we have an obligation to protect ourselves. And we do have to take care of making sure that if the community is not safe because of a wrongdoer, we have to identify that wrongdoer and have them transition out of the property. I want you to know that the most likely defense is, hey, it wasn't a nuisance. It didn't raise to that level. You can't prove it. Another defense that is often arising in nuisance-related activities in this community now is a mental disability. So I have often cases where I have a disruptive tenant inside a unit. They're banging on walls at all hours of the night. They may be swearing at people. They may be screaming intermittently. They're interfering with the quiet enjoyment of other people, and it's ongoing. I serve a notice to cure or quit for nuisance. Despite the notice to cure or quit for nuisance, the tenant continues to engage in that behavior. The client says, I've already lost 3 sets of tenants. They've moved out because of this disturbing person. I say, okay, let's proceed with the filing of an unlawful detainer action. We serve the unlawful detainer action. What happens? The tenant defendant gets free counsel. The attorney sends a letter requesting a reasonable accommodation as a result of the defendant's disability. For example, the person who is screaming at all hours of the night is a paranoid schizophrenic, and they need their medication to be stabilized in order to reduce the risk of this noise disturbance. Are they entitled to an accommodation? And the answer is, if it's noise, they probably are. And you may have to relocate the person to another location in the building. You may have to consider whether you can accommodate that disability. For instance, you could provide greater insulation. You can put the person in a different location in the building. It really depends upon the circumstances. But oftentimes when I'm dealing with disruptive behavior nowadays, I'm actually going to transition this dispute into a dispute about the American with Disabilities Act, the civil rights law in California, where we're not allowed to discriminate against someone who is disabled. We're entitled to request confirmation of their need for an accommodation, confirmation that they do have a disability. But I want you to understand, when I go to trial, it's oftentimes where someone has done something egregious. They're claiming a mental disability, but the accommodation cannot be provided because the person poses a threat to the safety of others. For instance, we had an individual who was attempting to set a building on fire. Tenant defendant claimed a mental disability, wanted an accommodation. We were able to successfully defeat that defense of violation of American with Disabilities Act, failure to accommodate, by saying this type of behavior is so dangerous, it can't be accommodated. The person needs to leave the premises. Arson is different than someone at night screaming and intermittently waking people up. And what happens is nuisance often evolves into a question of whether the person can be accommodated their disability. This happens when we have unsanitary conditions, where someone's cluttering and hoarding. They're a nuisance because they're attracting vermin or pests or cockroaches. We need them to clean up their unit. They don't clean up their unit. We serve a notice to cure or quit. They continue not to clean up their unit. We file the lawsuit. We get a letter from their attorney saying they have a mental illness. They clutter and hoard because of a mental illness. We want to give them the ability to stabilize their housing, remain in possession of the premises. You need to stop the process and allow them to have a cleanup service come and clean up their unit. That's how it plays out. And when someone raises the issue of a disability based upon cluttering and hoarding, we often have to allow them to be there, but under strict guidelines on keeping the place clean. This is different than when someone physically accosts someone. If we've got someone physically violent, they don't get accommodated because they're a threat to the safety of others, and it can't be accommodated. But be advised, don't be surprised if you retain my office to handle a nuisance eviction, and all of a sudden one of the defenses is that you didn't accommodate their disability after we requested an accommodation. We always have to engage in a communication about the accommodation. When we don't believe that it can be properly accommodated, we simply write a letter saying, we've received your request. We don't think it's reasonable. We cannot accommodate violent behavior. He poses an imminent threat to the safety of others. That's how it plays out. But this whole area of law has been commingled with American with Disabilities Act, civil rights claims on discrimination of those with disabilities. And all I can tell you is we work on a case-by-case basis based upon the facts of the case. Next, temporary restraining orders, a TRO. So sometimes we have such violent behavior. And I told you at the start that an eviction action for nuisance, someone engages in a physical violent behavior towards another tenant. You can serve a 3-day notice to quit. The tenant doesn't move out. How many days is it going to take to get through the eviction process? 90 days. So for 90 days, that wrongdoer is in close proximity to that victim. That's a long time. Sometimes where we have significant violent behavior, we will proceed with not only an eviction action, but seeking a TRO to immediately keep that person away from that victim. Many of my clients are property management companies. Many of my clients have buildings where they have front desk staff, where you have an out of control tenant who is engaging in misconduct towards staff, where they don't feel safe as employees of yours because of this person, and you need immediate assistance in protecting that person, we will proceed with the filing of a TRO. It's a relatively quick filing, if you sufficiently allege harm, physical violence, you should be able to get that TRO issued. You have to serve the TRO, and then there is a hearing for a permanent restraining order. I often will do that where there's an immediate need to proceed and safeguard someone. But I want you to know that if you need the person out of the building, an eviction action is typically the way that you have to go. Because a TRO will keep someone from a certain distance to another, but it doesn't sever their tenancy. These are civil harassment restraining order applications. And when a judge who's handling civil harassment restraining order hearings learns that it's a tenant-tenant dispute or it's a landlord-tenant dispute, they may tell the landlord, look, this issue doesn't raise to the level of a TRO. It's not egregious enough. You need to go and proceed with an unlawful detainer action. I told you the standard for an assessment of a case in a landlord-tenant matter is by a preponderance of the evidence. So you have to prove nuisance by a preponderance of the evidence. In a harassment hearing for a temporary restraining order or a permanent restraining order, the standard is higher than a preponderance of the evidence. It's by clear and convincing evidence. And so if you've got disputed facts or you've got two witnesses seeing two different things, you may very well lose a hearing for a permanent restraining order because you're not able to get to the standard of clear and convincing evidence. So be advised, there's a higher standard for a TRO. Domestic violence. Domestic violence involves a set of rules that are different than if it's just tenant on tenant violent, where there is no familial or relationship between the tenants. Domestic violence is where we have a violent situation that occurs within the unit, and there are certain rules that protect the victim of that violence so that they can either end the lease or preserve their tenancy despite the fact that there's behavior occurring in the unit that would typically qualify for nuisance behavior. Generally, and let's back up. I've got two tenants in a unit. They get in a fight. I can serve a 3-day notice to quit on both of them. They're unrelated to each other because we've got joint and several liability. If you're getting in fights at a party inside your property, that's a nuisance. I can clear the tenancy out. Where we have domestic violence, though, we've got to be careful. We've got to know the rules. And whenever someone presents to me a violent situation where we have individuals that may have a familial relationship, they may have an intimate relationship with each other, we've got to be careful because it triggers new obligations that don't immediately allow you to proceed with an eviction. A landlord shall not terminate a tenancy or fail to renew of a tenancy based upon an act against the tenant's household member that constitutes domestic violence, sexual assault, stalking, human trafficking, or abuse of an elder or dependent. So, how do we know that this is happening? You ask for documentation by a third party, a written report, a restraining order. So where we have a situation that qualifies for the above standard, we have to be careful. We can't immediately proceed with an eviction because you violated their rights. And oftentimes someone who is a victim of domestic violence will in fact notify you they're a victim of domestic violence, trigger the rules under the statute, and alert you as to what your requirements may be and what they would like to have happen. So remember, the general rule, a landlord shall not terminate a tenancy or fail to renew a tenancy based upon an act against a tenant's household member that constitutes violence, sexual assault, stalking, human trafficking. the documentation that you need to request or can request are one of the following: restraining order, protective order, documentation by a third party, a written report. 2, the person against whom the protective order has been issued or was named in the police report or any other permissible documentation is not a tenant of the same dwelling unit as the victim. Got it? Now, let's move on to the lawful reasons to terminate victims of domestic violence. A landlord may terminate or decline to renew a tenancy after the tenant has availed himself or herself of the protections afforded these laws if both of the following apply. 1, the tenant allows the person to come back and visit the property. The landlord believes the presence of that person is going to harm other people in the building, and the landlord previously gave at least 3 days notice to the tenant to correct either of the violations. And then we have privacy concerns. You're not to disclose any information to a third party unless the tenant has consented. I want you to recognize that where you have a belief that you've got domestic violence inside your unit, you want to contact an attorney to discuss what your options are so that you don't run afoul of the law. Because if you seek to evict, you may have ended up violating that victim's rights. And so we want to go through the process deliberatively, thoughtfully, follow the protocols in order to make sure that you have done everything correct in order to protect your rights, protect the victim's rights, and make sure you're not creating civil liability for yourself. Another important point: California Civil Code allows survivors of domestic abuse to request a change of locks within 24 hours to preclude the abuser from accessing the property. Sometimes you have in your lease agreements that says no lock change without the written consent of an owner. Well, in a domestic violence situation, under a scenario of this type where we have domestic abuse, if someone makes that request and you deny it, you've created liability for yourself. So always be very careful about domestic violence situations. Consult an attorney. Where we have tenant-tenant dispute in one building, 2 separate tenants, no relation, and they're simply physically violent to each other, that's different than when we're dealing with domestic violence within a unit. Next point. Some of you have Section 8 housing. Public and Section 8 housing is subject to VAWA, the Violence Against Women's Act. It prohibits evictions directly related to abuse. If your only investments are private investments, no Section 8, no public housing, then VAWA does not apply. But for some of my clients who are employees of Mercy Housing, employees of TNDC, Tenderloin Neighborhood Development Corporation, Catholic charities that run property that are part of public housing or Section 8 housing, there's a whole set of other protections that are afforded victims, and these are identified in front of you. Generally, a tenant cannot be evicted for nuisance or damage to property that are a result of abuse. That's the protection. The protections are afforded to undocumented persons. Housing providers can deny tenancy on other grounds unrelated to abuse. Victims can be evicted for standard reasons irrespective of abuse, but abuse of its own will not be a justification for eviction. What we're trying to do is protect and stabilize the housing of victims to ensure that the victim is not penalized by virtue of being a survivor of abuse. This is a benefit to those people who have been victimized, and the goal is to provide stabilized housing in these public housing scenarios and or Section 8 housing situations. If you have a Section 8 tenant and you have questions about this, by all means, please let me know, and I'll be glad to provide you information about it. Remember, dysfunction exists in society, and as a result of dysfunction, violence, anger, we're going to have it in our houses. We're going to have it in our rental properties. We just need to know what the rules are, what the regulations are, and how to properly handle it. VAWA does not apply when we're dealing with private housing typically. So despite me presenting it to you, remember, it is specialized. And the remedies for victims under VAWA, bifurcation of a lease, where you can divide the lease, you can remove the abuser from the lease, or the recipient of a Section 8 voucher may be able to break the lease and move into another location and move their Section 8 voucher to a different location. It's a bit complicated, but what we're trying to do is stabilize housing for victims or provide them a method to move away from the abuser in a safe manner without losing those public benefits of affordable housing to those victims. Now, there's another portion of this webinar that I want to discuss. And this happens intermittently with my clients, and I want to discuss it with particularity. What happens when you've got a vacant unit and all of a sudden you learn that 3 people are moved into the unit without your permission and they're quote unquote squatting? And you only learned about it 3 weeks after they moved in because you were on vacation. What are you going to do? Well, those people who broke into your unit are trespassers, and they burglarized your unit because they broke in without permission. Here's the problem. If you call the San Francisco Police Department and you just call the district and say, hey, I've got people who are in my unit, they don't have permission to be there. The police come to the place. The 3 people inside the unit show a bogus lease. And they show to the police that, hey, we have a tenancy here. We have permission to be here. The prior tenants gave us the right to be here. You know what the police may say to you? They may look at you and say, I'm sorry, Mr. Jones, this is a civil matter. You'll have to go to court on this. Police officers are scared to do something in a landlord-tenant capacity because they know that it's supposed to be done through an eviction lawsuit. So all of a sudden, you don't get the cooperation of the police to remove them, even though they broke in and burglarized your place, because these squatters are sophisticated. They know what they have to say because they've done it before. Or they present a utility bill and say, hey, we're on the utility bill. Or they show documentation that somehow links them to the property, despite the fact that they broke in. What are you going to do? Where you have a situation where people who have broken into your property and you find out they're living in the property without permission, do not call the police. Call 911. Tell them there's a break-in, an active break-in into your unit, and that you want the police there immediately. Because if you call 911 and it's an emergency, the police will come, and then you tell them, look, there's a break-in. They'll treat it much more serious, and you demand an arrest. You say they broke in, they're burglars, and you can get them out. If in fact that's true. If they're merely subsequent occupants who have resided in the premises and the master tenant vacated and they've been there for 6 months, that's not a smart thing to do. But where we have a locked building that was vacant and you have someone breaking into the unit, the police may not really deal with it. 911 with an emergency call will have an engagement that's much more serious, and that is more likely to result in the people being arrested and removed than if you call the district a station on a day and you don't treat it as an emergency. And I've got to tell you, I've got lots of clients who have had a situation where they try to get squatters out of a unit and the police say, I'm sorry, it's a civil matter, because they saw some document from the squatter attempting to allege that they have some sort of legitimate right of occupancy. If the squatter provides documentation that suggests a legitimate right of occupancy, You may be shooed away and stuck with having to deal with an eviction lawsuit, thousands of dollars in attorney fees, 90 days to evict. So my strong preference is if you believe you got people who broke in and they're trespassers and they don't have a legal right to be there, call 911. And also, if they're out of possession of the premises and you're sure they're squatters and they broke in, you can change the locks on them. You can change the locks on them. However, be careful. If they do have a legitimate right to be there because they're subsequent occupants and inherited the unit, and you lock them out, you've created civil liability for yourself. What does this mean? It means that before you make a decision, you might as well give me a call. We can have a meeting about it and come to a conclusion as to what to do. Sometimes I tell people, change the locks. They're trespassers. Other times I tell them we need to file an eviction lawsuit. Other times I tell them call 911. This happens sometimes on the death of a long-term tenant. Someone passes away in your unit, and all of a sudden, someone pops into the unit and claims a tenancy, or that they've been roommates for 20 years or 5 years, and you know it's not true. Well, you've got yourself a problem, especially in a place with rent control where you've got a baton pass of a below-market unit, and you've got the deceased grandson moving in from Berkeley to San Francisco to take the benefit of a prime lower Haight flat that's now $3,000 below market. Grandmother passed away and the grandchild comes into the unit. In that situation, you should contact an attorney to evaluate what your options are. Generally, the death of a tenant terminates the tenancy at the end of the month, and we may be very aggressive and say we're going to change the locks. However, if the deceased tenant, in fact, had roommates for many years, you're not going to be able to change that lock. It's going to be a question that we need to really think about as to what we're going to do. Rest assured, though, I have the experience and expertise to be able to respond to these issues. They're tricky, but you needn't be a victim by sitting on your hands and doing nothing. The most important thing is proactively address the question of what you're going to do by contacting an attorney and getting a fair evaluation. I tend to see myself as a practitioner of what I call statistical lawyering. I'm aggressive when I believe it's appropriate because I think being conservative ends up costing clients lots more time, lots more money, and is a lot more time consuming and sometimes puts you in a disadvantageous position. Remember though, you don't like my advice, I'll give you another attorney to get a second opinion. I'll give you another attorney to get a third opinion. You talk to 3 attorneys, you may get 4 opinions. This is not math. It's a statistical assessment of risk when dealing with fact patterns that are sometimes new, sometimes evolving, but you've got to be active on it. You don't want to sit 3 months with squatters inside your unit and then decide to contact me. The minute you know that that's happened is when you want to contact. So we are dealing with lots of problems throughout the Bay Area. Theft, addiction. We have lots of mental illness that is inspired by addictive behavior. And I can only tell you that during the pandemic, it's even been more aggravated with homelessness, with active drug use on the streets, with lots of people encumbered inside units, with unemployment. I don't have an easy solution to what is happening from a societal level. I do know that the police are overburdened, and I do know that public policy in the Bay Area is a bit off in how to handle this. The one thing I can emphasize, though, is where you have dysfunction inside your unit, where someone is misbehaving, I am able to address it either through a notice to cure or quit. It could be a letter, but if it becomes egregious and dangerous, you've got to act. Because if you don't and further harm occurs inside your building, you've got civil liability and your insurance may not even cover you because you were aware of it you sat on your hands and did nothing. So I want to emphasize that you want to be proactive in handling these disputes. I'm available, and most importantly, it's my pleasure and privilege to help you solve these problems. I have attorneys that work with me. I have offices in Oakland and San Francisco. We speak Spanish, we speak Chinese, Cantonese, Mandarin. We are capable of handling all the dysfunction. And while you think something is a new matter, we have probably dealt with it in the past, whether it's a murder inside a unit, arson, drug dealing, prostitution. We've seen it all. We're comfortable in helping you make good decisions about it. And it's our pleasure to be helpful as a problem solver. With that, I want to say thank you very much. It's, again, important for you to recognize that I want you to stay in touch. I send emails out when there's new laws out there. I send email updates as to what's happening with the moratorium in Alameda. I send updated information about fact patterns that have arisen, about new rules that you need to follow, but you need to be a subscriber to me either through my Facebook or through this bornstein.law/subscribe, and you will become more informed simply by being engaged with me through social media. And I try my best to consolidate information, providing weekly or bi-weekly or twice a month emails so that you're informed of what's happening as a real estate investor, a real estate participant, a landlord, whether you're a tenant. It's my pleasure to educate, and it's my commitment to you to continue to do so while we are in this pandemic and transitioning out. And hopefully we get back to normal by September, so that we can start to efficiently and better manage our real estate investments. Stay healthy, stay safe, have a great end of spring or middle spring and transition into summer. And I'm available for you should the need arise. Thank you very much, and my pleasure. If you have questions, by all means, email me. Thank you. Got a mistake in here. Great catch. You shut me off, right?
Yeah.